on the 6th day of November, 2010 at about 12 midnight. It was alleged that one Mr. Bello and one Mr. Yaro conspired to rob and did rob one Alhaji Adamu the sums of 60,000 naira and 6 cows while armed with sticks. This offense of robbery was alleged to have been committed at a Fulani settlement in Jigawa State. Bello and Yaro were arrested and charged with the offenses of conspiracy and robbery, contrary to sections 97 and 398 of the Penal Code of Jigawa State, Laws of Jigawa State 1998. It was reported that during the trial, Yaro died, and his name was struck off the charge sheet. At the end of the trial, Bello was found guilty and was sentenced to 21 years imprisonment. Aggrieved by the decision of the trial court, he appealed to the Court of Appeal Kaduna Division. At the hearing of the appeal, Mr. Bello's lawyer contended that the land trial judge did not warn himself before relying on the evidence of Alhaji Adamu and his wife. The lawyer submitted that for being evidence of a husband and wife and neighbors of Mr. Bello, they were tinted witnesses. Secondly, he pointed a contradiction in the evidence of Alhaji Adamu and his wife. First, Alhaji Adamu informed the trial court that it was dogs barking that woke him up, while his wife informed the court that it was Yaro and Mr. Bello that dragged her husband from the bed. Second, Alhaji Adamu informed the trial court that they hit him with a stick, while the wife informed the court that her husband was hit with a stick and knife. Third, Alhaji Adamu said they were attacked by 3 persons, while his wife said 2 persons attacked them. The counsel submitted that the apparent failure of the learned trial judge to resolve the contradictory evidence of Alhaji Adamu and his wife occasioned a miscarriage of justice. He argued that for the fact that the prosecution witnesses are husband and wife and also neighbors with Mr. Bello, there is the possibility that the case against Mr. Bello is a fabricated one, and so there is bound to be a lingering doubt or feeling about the guilt of the appellant, as it will be unsafe to convict, because either Alhaji Adamu or his wife must be telling lie as to whether it was 2 or 3 persons that committed the offense of robbery. On the other hand, the Director of Public Prosecution Jigawa State, who was the respondent at the appeal, argued that the purported contradiction and inconsistency in the evidence of the prosecution witnesses only exist in the imagination of the land counsel for the appellant. He contended that the issue of Alhaji Adamu and his wife being tainted witnesses was never raised at the trial court, hence it cannot be raised on appeal without the leave of the court. The DPP argued that there is nothing before the court to show that the appellant sought leave of this court or the court below before he raised the issue of Alhaji Adamu and his wife being tainted witnesses. He urged the court to strike out the argument canvassed by the lawyer. He maintained that there is no law which declared witnesses to be tainted just for the mere fact that they are husband and wife. He also submitted that a wife has been held to be a competent witness for her husband. On the first contradiction, he argued that there is no contradiction because when Alhaji Adamu was woken up by the dogs barking, there was no evidence which showed that his wife was awake then. He maintained that the only evidence before the court was that his wife woke up and saw some people inside her room dragging her husband, and that was what she told the court. On the second contradiction, he argued that there was nowhere in the evidence of Alhaji Adamu's wife where she claimed that Mr. Bello and his confederates stabbed her husband with a knife. He noted that what the woman asserted in her evidence in chief was that the Mr. Bello and one other person used sticks to beat her husband. On the last purported contradiction, he submitted that there is no contradiction at all because Alhaji Adamu was categorical that he saw 3 people in his house on the day of the robbery, while his wife stated that she saw only 2 people in her room, but she also had some other people outside her room talking. Land Council submitted that assuming but without conceding that there is contradiction in the testimonies of Alhaji Adamu and his wife, that alone will not warrant setting aside the decision of the trial court, because court has held time without number that for the contradiction to be fatal, it must relate to material facts that create doubt in the mind of the court as to the culpability of the accused person, which lead to miscarriage of justice.
After hearing arguments of both parties and after carefully going through the records transmitted from the trial court, the Court of Appeal found that the issue of Alhaji Adamu and his wife being tainted witness was not raised at the trial court, and the trial court did not decide on it as rightly observed by the respondent. The court held that the said issue cannot be raised for the first time before the Court of Appeal without the leave of the court first had and obtained. Thus, the argument relating to the issue was duly struck out. The court also held that the function of evaluation of evidence is that of the trial court, where the trial court has unquestionably evaluated evidence and justifiably appraised the facts, as in the instant case it is not the business of the Court of Appeal to interfere. The court also held that for contradiction in evidence of prosecution witness to be material and capable of rendering the evidence unreliable and incapable of being acted upon, such contradiction or inconsistencies must relate to material ingredients of the offense charged. They must be substantial and fundamental to the main issue for them to be fatal to the prosecution's case. The court then found that in the instant case the alleged contradictions in the prosecution witnesses are not fundamental to the main issue for them to be fatal to the prosecution's case. The court, even after it struck out the argument on Alhaji Adamu and his wife being tainted witnesses, still considered it for avoidance of doubt. The court held that in criminal law, a wife is a competent witness for her husband. The court also held that a court must be reluctant in disbelieving a witness on the ground that he or she is a tainted witness, and that an accused person can be convicted on the evidence of a single witness except where the offense charged statutorily requires corroboration. The court found that armed robbery, as in the instant case, does not require corroboration. Thus, the issue of contradiction and whether Alhaji and his wife were tainted witnesses were resolved in favor of the respondent. In a whole, the appeal failed for lacking in merit. It was dismissed and the judgment of the trial court was upheld.